opinion that I have already filed last week.
So let it be there. Yes.
Item.
Pardon. One modification is there.
Yes, sir.
Let's weekly list item 137.
137.
137. I pray lots of that it on third statements. I will intimate to the other councils.
Let it be there. It will not.
It's there.
Whenever it comes.
Today also after lunch, you're not sitting in division judgments.
I don't know how much time it will take.
Pardon to make a mention.
Item number 6. Ladies first. Ladies.
Yes, yes. I'm sorry, I have seen.
Yes.
My lords, it's a check bounce case of the year 2013, my lords. It may be listed for hearing.
You are accused.
I'm for the opposite party, my lords.
Who
For the
is
informant.
Who is for the accused? He has to pay you. That's all. Take it.
Obliged.
Which year matter?
2013.
13. Take it. Supplementary. Put it in the supplementary. Yes.
Obliged.
Yes. And you, if you know the other side lawyer, please intimate that I have mentioned it
My lords.
today itself.
My lords.
Item number 6 of the hearing is.
6 weekly.
Item 6.
Yes.
Here, I was just praying your lordship, kindly accommodate me on Thursday or Friday.
You,
I'm ready
you
otherwise.
tell your junior when it will come and I'll let you. No problem.
Great.
Yes, no problem. But it is 2004 matter, Mr. Bose.
My lord, I am ready. I have prepared the note, but other instruction is not there.
Material.
That's very, very important. And honest confession on the part of.
No, he always tells true.
Yes.
My request, my lord.
Yes. And round it, and we'll take it up. Next week,
Any week, Thursday or Friday, I'm ready.
let
Today is
it be there in the
Yeah,
list,
in the
not
list.
today. Let it be there in the list. Yes. Yes. Any mentioning?
I may be pardoned, my lord. Your lordship may kindly have a glance to the cause list.
We were
In which-
expecting you here.
Your presence is strong.
Anyway, tell me.
Yeah, it became late, so that I am making it through virtual.
It's all right. All right. No
So
problem.
your lordship may kindly have a glance to the cause list.
Yes.
Item number 147,
Yes. 147 and
147, 150,
yes.
and 157, 58, 59, in which TCR has not been received. Will your lordship hear without TCR? So I pray before your lordship restrict to direct to list it in the hearing after receipt of the TCR only.
Okay. Then when it will come, I'll pass that order.
Yes, my lord. It may not reach, so I am mentioning it may be listed in the hearing after TCR is received.
1 minute. If any matter is listed in the weekly, if teacher hasn't come, then tell the registry to call it. We don't need an order for that. These are appeals.
Unless
Anyway,
unless judicial order passed, they can automatically come. Section will be sent the message.
you
judicial
tell
will record
them that any matter which is listed for hearing, call for the record. Finish. Nowadays, that's not a problem. Electronically, everything comes. What is the big?
At the moment, if there will be judicial order, then the section will come for the case.
वो जो नंबर तेरा तीन कर देना तेरे ऑर्डर कर कॉल फॉर the टी-shirt ठीक call for the टी-shirt and it will be listed next week after it reaches. Yes.
Obliged.
Yes, Mr. Sambit Patnaik, are you mentioning anything?
No, my lord. My lord, I am in item number 50.
Okay, next up. Yes.
46.
It will start from 46.
46 to 67. Item 56, 46, kindly grant pass over.
1 minute. Let me reach there first. 40. Yes. What do you want?
Pass over.
Pass over. What is this matter?
My
Why
lord,
are you asking
if a
for?
lordship will not swear in a fix, my lord, my learned friend inadvertently has served a copy to the advocate.
State council.
But it's a business matter. I got the
Sir,
copy.
the copy. What is
How did
the?
they come?
No, what is this matter is about?
In fact, I was going through, my lord, an order rejecting a discharge application. They come up. Earlier, they had challenged that order of taking cognizance. And thereafter, they have filed this application, revision
You
for.
supply the copy next week. Yes,
Alright.
urgent. No urgency. Yes,
ଏଇଟା ମୁଁ ନେଇଯାଉଛି ଏଠି ଲେଖି ଦଉଛି ମୁଁ ଲେଖି ଦଉଛି
47, yes. Bail matters also, they don't come. Urgent next week. They want to be there. What to? Yes.
My lord, 47, my lord.
Hmm.
But I mean, so far the co-accused concerned, my lord, his bail application urgent to 26/7/24.
26 kar do. Yes.
48.
May I please assist? Discuss petitioner is in custody since 21/10/23 matter.
21/10?
23 matter. 21/10/23 matter.
Yes.
And contraband ganja is 41 kg 700 matter. This is the second bail application, and your lordship directed to renew the prayer after submission of charge sheet. Charge sheet has been submitted on 16/4/24 matter.
Any co-accused granted bail?
Sole accused.
Sole accused, ma'am.
Sole accused.
Sole accused. Criminal antecedent?
No, man, no criminal antecedent.
But now you have seen the Supreme Court judgment.
Matter.
We were lenient in giving the bail, and court says that you have to give reasons.
That is, ma'am.
What do you say? 41 kilo
Right.
ganja.
Lordship mentioned 37 bar, my submission recorded it was.
Check korbo. Custody, the custody 21/10/2023. And earlier the petitioner had approached this court by filing BL number 609 of 2024. This court by order dated 6/3/2024 is rejected the application, giving liberty to the petitioner to move application after the submission of the charge sheet. In the present case, charge sheet has been filed on
16/4/24. 16/4/24.
16/4/24. Thereafter, he moved application before the court below for grant of bail, and the sessions court, huh? And the sessions court comes special judge, Jaipur.
My lord.
Jaipur, white order dated 15/5/2024.
Special CORAM.
Special judge Koraput.
CORAM, not judge.
Koraput by the order dated 15/5/2024.
Koraput at Jaipur. Koraput at Jaipur.
At Jaipur, okay. Rejected the bail application on merit. Bail application on merit. Hence, the petitioner has approached this court. Mr. Ragada appears for the state and submits that there is a recovery of 41.700
grams, my lord.
700 grams
More than
of
commercial
contraband ganja,
More than commercial
which is more than commercial quantity. As such, 37, there is a bar under 37 operates. How many witnesses are there? Charge sheet witness?
Charge sheeted witnesses, my lord.
Legal counsel for the petitioner submits that the petitioner is in custody since 21/10/2023. There are how many charge sheeted witnesses?
My lord, I said preliminary charge sheet submitted.
Preliminary. Only at this stage, only preliminary charge sheet has been submitted and submitted. There are many witnesses cited in the charge sheet, and final charge sheet is still awaited. Therefore, it would take considerable time for commencement of the trial. In that view of the matter, he seeks intelligence support, taking into consideration the aforementioned custody and recovery of contraband. I mean, inclined to grant bail, subject to condition, antecedent and everything.
There are
15 numbers of witnesses. Charge sheeted
The
witnesses.
preliminary charge sheet.
Preliminary charge sheet.
Obliged.
Yes. Yes, 49.
Yes, I'm for the opposite party.
What is this matter?
Matter relating to cancellation bail.
What are the allegations against you?
Allegation that they have his petition that they did not, I have not disclosed the petition before the court.
What is the concealment? Yes, Mr.
My lord, what happened in this case, my lord, though the petitioner, my lord, filed, the opposite party, my lord, filed 3 to 4 anticipatory relapse before this Honorable Court, my lord. Some cases they had withdrawn and some cases disposed of, my lord. Thereafter, my lord, this Honorable Court directed him to surrender before the court and take the appropriate remedy, my lord, available with law, my lord. Thereafter, he remained silent. After some years, he approached the trial court, the opposite party 2 and 3, they approached the Sessions Court, my lord, for anticipatory bail. And Sessions Court granted them anticipatory bail.
And where is the application of anticipatory bail?
My lord, that is in the case, my lord.
Where is that?
That is an annex, my lord. That is an annex, my
Bail
lord.
application. Three. Three, na? Bail application.
Annex of 3. As page 31. They are sole
Yeah,
subject,
but
they have
para 10
Annexed
he has
four, ma'am.
disclosed. ABPL number so and so before the High Court.
Yes.
Before that, how many cases he filed? He has
Man,
not.
they have not mentioned
How
all
many
the
cases
my lord.
he have filed?
Though they have mentioned, my lord, some
Now
cases,
in-
some.
Here, my lord,
How many cases you have filed, you tell me?
but in the meantime, matter has been compromised. Lord, see, today I also filed affidavit.
Compromise is something different. I am not cancelling the bail. You
Yes.
tell me how many cases you have filed. It is against the money. You are concealing the facts from the court.
But what happened in this case, my lord? They have filed 1, 2, 3 ABL applications and one CRMC and a SLP before the Apex Court, my lord. All total 5
All
cases.
these things are concealed.
And they have also, my lord, they
They are already paid.
they have taken another, my lord, ground for a concession bail, my lord. They have stated that there is no such compromising. In fact, my friend says that there is a
There is
compromise.
compromise. Also, I had to, they are paid 1
They have
lakh,
ground
1
two
crore
grounds, my
78
lord.
lakhs.
One suppression of earlier application disposed by this Honorable Court, and second is, my lord, the matter has not been compromised. But he has got instruction.
But he says that it's not compromised. That's what.
Yes,
my lord.
I have also filed affidavit.
Okay, let him come. Let him come. Pass out.
Next
Get
month.
no.
Friday, assume
No, 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 I'll dispose it up and I'll impose, I'll not cancel the bail, but I'll
Tomorrow,
impose,
assume tamu khabar
impose cost.
Tomorrow, assume
Huh?
tomorrow, assume tamu khabar degi.
Why tomorrow? Today only. Wait. I'll impose cost. And now you decide the cost has to go to whom? It has to go to legal services authority.
In fact, both the, my lord, the informant and this petitioner, opposite party, my lord, they are partners, my lord. The manager and the
Yeah,
director.
let him pay some cost and to the legal services. State legal services. Pass it over.
Inform kar diya.
Pass it over. Yeah.
Petition council not there.
Pass it. Yes.
Item 50.
In item number 50, my lord, I have I am through virtual mode, my lord.
Yes.
In
Noting is there, my lord.
item number 50, my lord,
not complete.
my lord, I have instruction to appear for opposite parties number 2 to 4. I will file my vakalatnama today, my lord, before the registry, my lord.
What is this case?
Cancellation bail, my lord.
They have filed one application for cancellation of bail granted to the opposite parties 2 to 4.
In fact, my lord, what happened in this case, my lord? One of the petitioner offences are available initially, my lord. 50 except 506, other offences are available initially, my lord, at the time of registration, my lord. One of the accused arrested, he has petitioner 4, my lord. He has a release on bail by the court below, my lord. Since offence are tribunal arrested and 506 only non-bail offence. There are 2 of the opposite but 2 and 3, my lord. They have released on notice, my lord, issued them to 41. They had complied, my lord. 41A. And thereafter, my charge sheet submitted, adding the offence 326, my lord, which is life imprisonment there, my lord. Thereafter, they accordingly, after submission, court below issued summons, they appear and release on bail. And against that, they came forward. And
What is the ground?
grand, my lord, the 326 there, the court will have no power. That is there.
I'm passing it or I'll dismiss it.
Obliged.
Nobody appearing for the petition, Mr. Chan.
Pass over.
Pass over.
Otherwise I'll dismiss. Yes.
51.
After they did.
Power, my lord,
You file power.
yes, my lord.
Aji they did court.
Today only.
Today, my lord.
Where are you? You are in Cuttack or somewhere else?
Yes, my lord. I am in Kotak, my lord.
You come to the court.
Yes, my lord. My lord, because of my son's examination, there is late, my lord.
No problem. No problem. You come
Yes,
at 2 o'clock. Give
Yes,
the
my
vakalatnama so that I can.
Yes, obliged, my lord. Obliged.
My lord, item number 51. My lord, I am in virtual mode, my lordship. My lordship, I met with an accident on Friday and I have got fractured leg and multiple injury in my body. So I could not appear before your lordship
Okay,
in person.
you receive injury.
Yes, my lord.
Okay.
So
You are appearing.
I will.
Who is appearing?
No, I will conduct this. I will conduct. My lordship, I will conduct this matter.
No, you must take rest. Why will you conduct?
My lord, this is
I'll adjourn
the
you.
appeal against final order of confiscation. And your lordships kindly see the last order.
Whatever. You next week. You
My
are
lord,
not
so
well
what has
controlled.
happened? No, my lord, I am only to say that on the last order, your lordship can see 15/7/2024. 15/7/2024.
15/7.
Yes, 15/7/2024.
Yes.
My lord, my lordship, this is a appeal against final order. Nobody is appearing. They have taken stay order. And since 25/6/2024, nobody is appearing. And on several, and this was the last chance. If they will not appear,
Yes. The matter was taken up on 15/7/2024 and the following order was passed. None appears for the petitioner even today. In view of the non-appearance, it appears non-appearance on behalf of the petitioner. It appears the petitioner is not interested to proceed with the same. Hence, dismiss. Yes. Yes. I have dismissed. Okay.
yes, madam. Obliged, madam.
Yes.
52, Mr. Das will appear in personal defense.
No, he is appearing.
No, my lordship, this is my lord, this is the appeal which has been abated since long. And
Yes.
presently the legal it is their case that legal representatives, they will they have filed one substitution petition as well as an limitation petition. So far as substitution, there is no provision of substitution so far as the Special Court Act is concerned. And so far as the limitation is concerned, since 2013 and 2018, father and mother has already been expired. And they have filed the limitation petition in the year 2024. That is after one.
I'm filing.
Yes, I have filed objection
File
and also.
And but
Yes, I have already.
in a confiscation proceeding,
There is no
if the appellant dies, why can't they be substituted?
And
After all, their properties are involved.
Properties are not in the name of those legal representatives. This is the proceeds of the crime. And if the property would have been there in the name, it is not a inheritable property. As it is a crime product, my lords, proceeds of the crime.
Whether the accused has been convicted.
No, my lord.
Yes, it has been abated since 2013 and 2018 respectively.
Now imagine a situation, if the trial is going on and the only accused has died, okay?
No,
Only
two
accused has died. Confiscation proceeding is going on. Just imagine a situation. Confiscation proceeding is going on.
Yes.
Insofar as the trial is concerned, the LRs can't contest it because there is no conviction. 394 doesn't apply there. Only after conviction.
Yes,
then the property goes.
No,
If he is convicted, if he is convicted, his appeal is pending. The LRs can move one application under 394 and contest it and get an acquittal, and thereafter the property will be released. But imagine a situation where the accused is in the trial stage, he dies, and confiscation proceeding has been initiated. The properties are confiscated. What is the remedy left to them?
My lordship, during pendency of the trial, my lordships, if a person dies, it will be abated. The trial will be abated. And so far as the confiscation is concerned,
that abatement is a permanent abatement.
Permanent
because
abatement.
LR can't come and contest it.
Yes,
because there is no stigma attached to that.
No stigma. In that
then
case,
what will happen to confiscation proceeding?
My lordship, in this case, what has happened, my lordship, they have contested in the confiscation proceeding before the authorized officer. And thereafter, they have challenged it in the Honorable High Court in the present criminal appeal. during the pendency of this criminal appeal, both the delinquents they died, one in the year 2013 and one in the year 2018, and today it is 2024, and they are the present LRs are the sons in favor of which there is no property stands, and that has not been confiscated. So our case is the property accumulated by the main accused in name of his wife. It is not a inheritable property, my lords, and the proceeds of the crime cannot be inherited. And so far as the
proceeds
limitation
of the crime, these are Special Court Act provisions. Here,
Yes.
these confiscation are contingent upon the outcome of the trial.
trial.
Okay?
Yes, my lord.
During
Yes.
the trial, the accused dies.
Yes.
There is a dichotomy of how to deal with it. You
No,
address
wha-
that issue. These are legal issues.
Yes, and so far as 394 is not applicable here, and so far as
The trial has abated. Trial has become
Yes.
that abatement will never be revived.
yes,
The abatement will never be set aside because the accused has died.
that
So since the confiscation is contingent upon the outcome of the trial,
yes, ma'am.
what is the legal position?
And my lordship, so far as the law is concerned, my lordship, as soon as the delinquents died, it is automatically abated. This appeal has already been
I
abated since
understand.
2018.
This much I understand, but you have to address this issue.
Yes,
You
sir.
can't leave these people to lurch without giving any
Yes.
remedy.
I will address, my lordship.
You
And
address
another
this
thing is
issue, you know,
limitation.
if the accused persons are convicted during the pendency of appeal, if they dies, then they have a remedy. Why? They can continue with the appeal and get an acquittal, and property can be released thereafter. But during the trial, if somebody dies and the trial is abated, what is the remedy?
Yes, my lord. So I will.
What is the remedy? According to me, they are remediless.
No, so far as that, if
Do you
it
have
would have
any,
been in
any judgment to that effect? Any High Court, any Supreme Court, anything?
I'll bring it.
no, my lord.
Did you follow what I'm trying to tell?
Yes, my lord. Yes, my lord. During
There
trial,
is no
the-
point repeating same thing. Don't repeat same thing. The facts are very clear.
Yeah, but-
And you are confronted with a situation that you are remediless.
yeah.
What is your answer to that?
One cannot be remedied. Answer them. The legal heads are the.
You have to answer. Whatever I am saying, you are trying to repeat the same thing. You are
And
supposed to tell.
I'll come with authority. Come with authority.
Yes, Mr. Das, you have to address this issue.
Yes, madam.
If you have any judgment of any High Court or Supreme Court, you please tell me.
Yes, madam. Yes.
Because
So let it
these
come
are
up.
the proceedings contingent upon the outcome of the trial.
Yes, madam.
Yes. Next week. Huh? Objection taken on. Objection on facts is neither here nor there. This is a legal issue.
Yes, madam. So I will address.
That will be taken on record, madam. Affidavit.
Oh, that is taken out.
Great.
Taken on record. On the request of Mr. Das, urgent to counsel, the objection filed against the applications are taken out. I'm sure in the objection you might have said this happened, that happened. That is neither here nor there. You try to understand the
My lords.
problem.
Once we got it.
Address that. Yes.
53, my lord, it may be added to the hearing list. It is a misappropriation case, my lord. I have already received the paper book, my lord.
53, let's say they.
Let it be added to the hearing list.
Weekly list maybe.
Weekly.
Ready for hearing.
Okay. Matters are ready for hearing. 2015 matter, huh? Including the weekly. Yes.
54.
A big matter. Edit, huh? Adding the weekly. Yes.
5.
May I please, Lordship? Lordship, here the petitioner convicted under section 138 of NIA.
Yes.
Lordship directed me to return the amount to the opposite party. I am arranging the money.
I can't keep on waiting for your arrangement.
One more.
I'll dismiss it and you arrange it, give it and move application.
One more week, maybe.
What is the check amount?
45,000.
40?
5,000.
And how much, how many hearing have you seen? How many hearings? Can I count for you?
No, Lordship.
Cannot count for you. From
Last chance,
it is pending since 2011.
Lordship.
45,000.
Lordship.
Do you expect the High Court to waste time like this?
No, Lordship. One last chance, maybe.
No, no question. 2011 the matter is pending and you are taking time after time for 45,000 and you are wasting judicial time like this. Why should the court will interfere?
Well, next week.
No, next week. By 2 o'clock, if you give it, give, or otherwise I will dismiss it.
Only pass over. I will take insurance.
Pass it over, otherwise I will dismiss.
56.
By 2 o'clock, come with this thing. Otherwise no question.
Item 56, my lord. I have given the instruction to deposit the amount, but they have not deposited the amount. Not informed me. I have 3 times I have telephoning, my lord. Either they are responding, my lord. He's saying I am staying there. Dismiss the revision. No instruction, my lord.
The matter was taken up on 15/7/2024. Following order was passed.
Yes, ma'am.
Mr. Rautrai and Constable the petitioner submits that despite informing the aforementioned order,
Yes, ma'am.
and asking him to comply the order of this court, the petitioner is non-responsive.
Yes, ma'am.
Non-responsive. In that view of the matter, the petition is dismissed. The revision petition is dismissed.
But he will deposit the amount that dismiss for default, then it can be.
Dismiss, you deposit, then I'll revive.
Yes, yes. If in future.
Once deposit, then only.
My presence.
What can a lawyer do?
Yeah.
You tell me, he tells.
Many things, but they are not responding.
Communicate the order at least. Lawyer's prerogative only.
Beyond that, a lawyer can't do anything. And
I
these
can
people are
postpone email
taking
that.
High Court proceedings so lightly.
Exactly, my lord.
Let it be dismissed, we will see.
Yes, ma'am.
If he comes 75,000, he would have
Yes,
paid.
yes, ma'am.
Now he has to pay more than that.
Yes, ma'am.
With cost, he has to pay.
My
If
presence
you
for
move application, he has to pay the cost.
Exactly.
the 1 lakh cost has been imposed by the trial court.
So therefore, it was decided that 75, it's all.
Yes, yes. 72,000 some amount, not 75.
Anyway.
Yes,
My
ma'am.
presence for the bank may be required.
Huh?
My presence for the opposite party bank.
Yes, both the president.
God bless.
Yes.
Not an election.
57. 57.
57. Who is appearing? Application under 239 dismissed. Against that, he has filed it. This petitioner is agreed by the order dated order dated 10/2/2023 passed by दिख रहा है ना passed by special judge होगा special judge क्या कुछ भी नहीं so whereby the application of the petitioner under section 239 CRPC, bring for discharge from all the charges leveled against him has been turned down. Has been turned down. Turned down. The non-APS for the petitioner. Non-APS for the petitioner. In the interest of justice, urgent to make the court. Made clear that if in the next date appearing nobody appears, the same shall be disposed of on its own. Yes. Next.
58.
Yes, my lord, this can be disposed of, my lords. This revision directed against an order of conviction under section 468, 471, my lords. 3 years, sentence is 3 years and 2,005 amounts. This pertains Ranchi University BSc, BD certificates, my lords. And
Yes.
PW7, who hails from Ranchi University, my lord, he deposed on equivocal terms. That
Somebody was appearing.
yes,
sir.
in fact, today is the day. May I pray, my lord, sir, let it pass it on.
Pass
Can
it,
we dispose?
pass
my
it.
lords?
Or we will dispose it up. There is nothing.
Yes, it should be disposed.
Because
59.
conviction can't be set aside.
Correct.
Because the evidences are such conviction.
59.
Yeah, lordship, only record my submission, only I'm indicating, lords, para 14 of the appellate court judgment. That's,
I know, right? Remember that. I know.
and
I
the,
quote that rather.
yes, and the key witness is PW7.
7-7. Yes.
59.
So lordship dispose it.
And letter come.
Huh.
Letter come. Pass over. Yes. 50.
59.
What is this? Conviction. Nobody appears. Password. Password. Yes.
60.
Yes, Mr. Raghuda, what is this matter? By way of last opportunity, matter is adjourned, and you are supposed to verify the record period already undergone.
Copy not served, my lord.
Arvind Mahanti.
Copy not served.
Just take it up.
What are they? They have filed, my lord, miss case, my lord. What are they? Miss case to 18 of 2012. Back here for conversion of criminal revision.
Three 25, read with section 34. Yes.
Only your lordship, I have to, they will share that the period of undergone that was to be
Yes.
verified.
Where is the trial court order? Even trial court order is not there.
And the copy also not served.
How have you filed this appeal without trial court order revision? Only appellate court order, but that's all. There is nothing.
I'll produce that. Email.
There is no defect pointed out. Let's see.
It can be converted from CRLA to say criminal revision. For that, we may not the this may not be. Pointed out the defects. Normal case.
In the present revision petition, petitioner is challenging the order dated 14/12/2021 passed by the learned additional session judge, fast track 1, Kandamal, Pulwani, in criminal appeal number 2/31 of 2010. However, in the petition, the trial court order is not enclosed. The petition appears to have been filed very casually, casually, which is pending since 2012. Since 2012, by way of last opportunity, 2 days time granted to the petitioner to cure the defect. In the event the defects are not cured, the petition shall be dismissed without notice to the court.
Those certified or not, the rest of
Whatever
the
you do, it 2012 you have filed so casually two papers with nothing.
I mean,
Another copy to this.
It will be dismissed without
Mal.
further notice to the court. 2 days.
my lord.
One 59 টা করছি
59
just
First-
one person
first to
what's a conviction the other fine
59 1 minute 59. None appeared. You didn't appear last time also.
no my today I taken pass out
Huh?
today 59 time taken pass out.
But it's very good that you, whenever you come, wish you come, whenever you don't wish you.
Sorry, my lord, I didn't.
One hearing you are there, another 2 hearing you are not there. Again, you appear.
I'll not,
After disappear.
I'll not take maximum time, will take maximum to 5 to 10 minutes, this will finish yours.
Tell me right now. Offense?
498.
You are,
Conviction 498 surplus B, your lords.
who are you? You are husband.
Husband, your lords.
Yes.
The trial.
All other accused were
acquitted, your lords.
acquitted.
Acquitted.
You are the husband.
Yes, 498 conviction could not be found, your lordship.
Hmm.
And because cruelty has not been proved, your lordship, only conviction so far as 498 surplus B, your lords.
Surplus B.
B, your lords.
Yes.
We get it.
Surplus B. What? Yes.
Here on all total 9 PWs are there, your lordship. And out of
All you have been acquitted in all the 498 clause B.
conviction, lordship.
Yes.
Clause B, your lordship said the harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security,
Right.
or is on account of failure by her or any person related to her to meet such demand. Here were all the independent witnesses turned hostile. They had not supported the prosecution case. So only remaining witnesses rely on lordship PW1. Urmila Mahapatra is the mother of the informant, lordship. PW3, Krishna Mahapatra, father of the informant. And of PW3 only informant herself, then IO, lordship. IO PW9 only proves so far as the marriage part is concerned and seizure of the dowry articles. So for PW1, 2, 3 is concerned, lordship. Those are the interested witnesses.
In these kind of cases, do you think that you will start demanding outside? You will demand the family members only. The family member will only be the witnesses. Who else?
That's true, lordship. So now that so far the PW1, 2, 3 parties concerned, each of their evidence are contradicting each other. So far the quantum of the amount has been demanded, lordship. Sometime the lordship PW2 stated the lordship, the father of the petitioner demanded the money and he paid the money to the father of the petitioner, lordship. But so far the PW1 is concerned, he stated that, your lordship, the money has been made by the all the family members so far the petitioner is concerned. And accordingly on the before the date of marriage, 50,000 has been made payment of us. But PW2 stated, the father-in-law stated that none on the date of marriage, we paid your lordship 5,000, and rest of the amount paid after the marriage. So this being the contradiction. And only your lordship, 2004 your lordship case. And I convicted, trial phase convicted 2003 your lordship. Lord and Hon'Ble could not found so far the allegation part regarding cruelty, etc. lordship. Only found so far is the additional demand of dowry approach to 10,000. So my respective section 4 is there, your lordship, giving and taking down vice versa, your lordship. If your lordship, he admitted that yes, also I have been taken the money for him, your lordship, on demand, then he also same liable for me, your lordship, because I have demand and he has been taken. And 406 has not been there, even if charged there, 406 conviction is not there. Now only remaining is 1, 2, 3, they convicted. And I filed an appeal. The appeal has not been hard on merit, your lordship. Your lordship, an appeal, it has been stated in the appeal judgment. Paragraph 4, when the appeal was called for hearing, the counsel for the appellant did not turn up. So here 403 of the CRPC is violated because the statutory appeal, lordship, if the appellant has not been participated, then your lordship, state council has to be made engagement that the appeal has to be heard. It has not been heard on merit, but judgment has become confirmation, lordship. My respectful submission, lordship, if possible, lordship, POI can be applicable so far this case is concerned, because only 1 year, 2,000 rupees, and case of 2004 year, lordship. Accordingly, lordship, judgment may can be. Accordingly, lordship, the case may can be considered, lordship. And 1, 2, 3 year, lordship, you gone through the PWs, definitely come to come, there is a clear cut contradiction between them. And the finding of the trial court so far this was contradictory parties concerned, I am coming to lordship. He admitted that there is a contradiction. And another thing, your lordship, I filed a judgment also. This informal lordship so initiated a proceeding for divorce against me, lordship. In the divorce petition, she could not be succeeded because she is unable to prove the case, lordship. That judgment I filed, lordship. She could not unable to prove the demand of dowry. She could not unable to prove that tortured party is concerned. According to his divorce application became dismissed.
She filed the divorce.
She filed, lordship. That has been dismissed, lordship. But unfortunately, that has not been taken into consideration when the trial is made so far the present case is concerned. That has not been came into record. But the
Where is that judgment?
that is a lordship filed in a separate memo in
Yes.
civil branch.
Show me.
Made civil suit of 141 by 2000.
Show me. Where are the findings?
Made civil suit of 141 by 2008. The two judgment I filed. One is the trial court judgment so far my this present.
Court 141. You show me.
Yes, my lord. This is 141 of 2008, lords.
Findings. Which part of the finding will help you?
Paragraph 12 and 7 glance.
12.
Findings. It is the specific evidence of the what paragraph 3 years. It is the specific evidence of person that.
Which para? Sometimes you say.
Paragraph 12, lords. That's on page 12 of the judgment. Paragraph 3, lords.
12 para
3.
Reading
The
something
specific
else.
evidence of the person that on 48/12/2003 the respondent.
I'm not able to get it, sir. Page 12, internal page 12 of that judgment.
Yes.
Of the suit court.
Yes.
Para 3.
3 years.
It is specific in it. Para is not.
Specific evidence of the person that on 48/12/2003 the respondent left her marital abode. That is the rented house is situated at Hon'Ble, and after waiting for about 6 days on 3/1/2012, the petitioner left the rented house along with her father. It is not forthcoming from the evidence of the petitioner that she had taken any effort to save her marriage when the petitioner, as it appears from the materials in the record.
These are on desertion. Harassment.
Divorce has been filed on the grounds of cruelty, torture, lordship, and demand of dowry, lordship. And that finding has been given that it could not be proved according to lordship dismissal, lordship.
This finding regarding non-conjugation also. There is no specific finding regarding the harassment.
That's true, Your Lordship, but it has been, divorce has been filed on that ground that could not be proved, it has been dismissed. And so
This
far,
is regarding mental harassment for non-consummation of marriage which was not believed. Where is the harassment? Where is the finding regarding the dowry
Lordship,
demand
the
and
grant, so far the petition also, what is the prosecution case there, Your Lordship? The judgment, Your Lordship, first page.
you have taken 10,000 rupees and you put it in the bank and all.
Then she has been withdrawn, Your Lordship. She admitted that amount in the trial court judgment, that amount she has been deposited, joint account, it is deposited in the bank when they are staying in the rented house. Then when the infant suspend illness, she herself withdrew that amount and she admitted the fact before her father that that amount I have been withdrawn. And in fact, the dissension arose between them for that amount alone. She admitted collected the amount from the bank and that money she has been paid to her father because of the.
What is the position in the marriage front after this judgment? What happened?
So far the present she is now residing with her parental house, so there is no relationship.
Marriage still subsists.
There is no relationship and could not
May not be relationship, but marriage still subsists.
Yes, after dismissal of this, Your Lordship, after dismissal of this marriage still subsists, Your Lordship. And again, another thing you also glance, the internal page so far the trial court judgment that I filed in separate memo. So
what is the penalty? Due to
1 year, 2,000 rupees fine, Your Lordship.
Fine is 2,000. I'll increase the fine.
Only 2,000 fine, Your Lordship.
I'll increase the fine. And so far as the sentence part is concerned, I will give PO because the marriage is still subsists. You have to pay something to her.
Some lesser because
Reason you have not written this reason, that is the finding. That's the finding. So you have to pay. Sentence PO and fine enhanced. Permission.
Mandirore again puja korchundi, Lordship have a glance to their people.
Whatever you have to pay something.
Obligation, deal of
How much undergone? Undergone. Period of undergone.
I have no knowledge about that, Your Lordship. If the LCR can say so far the undergone part is concerned.
Might not have undergone.
It may not be a Lordship because of fornicated case may not.
Yes.
The deal of this.
Yes. This for the one. अभी दे दो तक रिजर्व कर दियो अब तक दे दियो हाँ next
61, some lesser amount so far increased part, your lordship, because of they are priest of the temple. 61.
Even I have instruction from the local council that the both the parties are now married elsewhere and they are living separately. So, but I could not get any affidavit because the lady.
This is 125 proceeding.
You 125 proceeding.
I'll dismiss it.
Let it be dropped. Let it be dropped.
No, I'll dismiss it.
No instruction on the ground of no instruction.
You are for petitioner.
I am for the
The
petitioner.
council for the petitioner submits that this is a proceeding arising out of an application moved by the petitioner wife under section 125 CRPC seeking maintenance. The council for the petitioner submits that the parties have separately parties have already married married and settled separately. Separately, and there is no instruction on their behalf. In that view of the matter, the petition is.
That's why just add one line instruction from the local council.
There is no instruction. There is no petitioner has not received any instruction either from the his client or for the instructing council. Hence this. Yes.
62.
Let's see, item 62. Let's see, kindly taken up next week.
You tell me what is this case.
Let's say the appellant has been convicted.
You are a permanent counsel here for asking for adjournment.
No, let's say the instruction got from my senior.
You maybe what is the case?
Let's say the matter is the appellant has been convicted under the section 363 and 376. The punishment sentence undergo concurrently arrive for a period of 5 years and 7 years respectively, and to pay fine of rupees 5,000 on his account.
Weekly.
Weekly.
No.
Yes.
63.
Item 63, my lord. I have to take instruction, my lord, that 8 accused persons face the trial. They have convicted under section 307, 325, 320, my lord. Then, my lord, appeal preferred to Sessions, my lord. Sessions case, my lord, the sentence was modified. Only 2 persons were 307 convicted, and the rest of petition, my lord, acquittal, my lord.
Not acquittal. Convicted under section 325?
My lord.
324.
My take instruction on the ground, my lord, that out of, my lord, 8, my lord, 4 accused persons, my information died, my lord.
No, two died.
2 died.
First 2.
No, my lord. Lakshmidhar Padhi and Arjun Padhi.
No, Ramachandra Padhi died.
Ramachandra Padhi.
The main accused.
Ramachandra Padhi died. Lakshmidhar Padhi.
Arjuna Padhi and Padmini Padhi. 4 জন মধ্যে ভালো instruction নেই
There
হতো.
is no Lakshmidhar here.
Lakshmidhar Padhi, in my appeal.
Lakshmidhar Padhi is the. Just he come to the cost title.
Cost title, so that here, my lord, 2 appeals.
Two.
Here, two appeals are filed, my lord. I have filed, my lord, criminal division 1108 of 2013, my lord.
1108.
That is my file, my lord. My friend file, yeah, another file.
In this case, Ramchandra Padhi has died, and other people.
Ramchandra Padhi, Arjuna Padhi.
Arjuna Padhi.
Another accused, my lord, says out of, my lord, 8, 4 accused died, my lord. In the 4, I have to verify, my lord. He also take instruction whether 4 other 4, 2.
Total 6 জন accused ভিতରୁ ବର୍ତ୍ତମାନ appeal जो revision pending ଅଛି ତାতে 2 জন dead ହେଇଛି.
In the first appeal.
My lord.
The other one. Lakshmidhar also died.
Lakshmidhar जो acquittal against modified ହେଇଗଲା sentence ତା against जो appeal file ହେଇଛି ତା ଦେହରେ Lakshmidhar died.
Lakshmidhar died. So the first relief. 108. And counsel for the petitioner submits that petitioner number 1 and 3 have expired. On
my lord, मुझे verify करें.
Expired. Therefore, the present petition stands awaited insofar as petitioner number 1 and 3 are concerned. He further submits that he would seek instruction insofar as the other seek instruction of the well-being and whereabout of other petitioners, these the matter and so on. Second में लिखो in the 76, in this appeal, opposite party number 2,
4 and 6.
4
and 6.
4 and 6 have expired. Therefore, for them, the appeal stands awaited. Insofar as the other opposite parties are concerned, the counsel for the petitioner will seek instruction.
No, I am for the petitioner. Opposite party
will seek instruction regarding their well-being and whereabouts. Leave the matter, both the matters. Please, both the matters.
Date. 4 weeks time have you given for that?
4
weeks time.
4 weeks. 2013 matter, 4 weeks. Next week.
Not
next week.
At 15, 2 weeks minute. Not 2 weeks time.
Why are you delaying it? 2013
Delay na se.
matter.
Moria is not kitchen. I am
Are
you waiting for natural death up to the case? Keep on adjourning till all of them die.
Actually, instruction of bracket and mild monetary instruction would have.
Therefore, 2 weeks. Thereafter, we will dispose it up. There is nothing in this matter. Yes.
Date.
2 weeks.
6.
64.
Please, Your Lordship. This division is directed against the judgment passed by the lower appellate court in confirming the conviction rendered by the learned trial court,
Yes.
punishing them for under 307, 5 years and with fine for 1,000 rupees. My humble submission, the total case, Lord, the entire case, the entire scenario of the prosecution is reflected on the civil dispute. Because both the parties, the informant and the accused person, they're agnostic relation, and there is a civil dispute relating to homestead land itself. My lord, if your lordship permit me, that the genesis of the occurrence and the nature of the injury and the attending circumstance are the
one of the informant has received injury.
Informant, pardon, the informant is PW5, the wife. Victim is the injured is the PW6. That means not the yes, injured is the
PW5 is the informant.
Informant was wife.
PW6 is the injured.
Yes. And therefore, my lord, in the case, my lord, the doctor.
That is what you are saying, civil. Injuring someone is civil.
PW8 doctor says, one is abrasion, and nonetheless, the first injury finds place on the skull, but the gravamen of the injury is so minuscule, as your lordship may find. There is very
head injury.
Head injury, very minuscule, it's very small, and that is doctor has never opined that such an injury has been intended to be inflicted with the intention to cause, any fatal injury leading to the death. So these are the very important point, my lord.
How the doctor will testify this fact? Your intention. Your intention has to be elucidated from the manner in which you have attacked.
Coupled with, because the doctor has been given the opinion relating to
what was the weapon?
Weapon, my lord, crowbar. One is crowbar, and other is cutlery. So far the cutlery part is concerned, there is no incised wound as it is borne out from the record. And the sabal, the crowbar is the sabal that has been used, but vis-a-vis the injury inflicted and the manner of assault as attributed by the appellant, my lord, it does not have a coherence at all. But the skull pre average choto injury. So, my lord, it knows, my lord, if, my lord, the enmity between, nonetheless, the enmity between the parties is a double-edged weapon, but centering around the civil litigation.
That's why the appellate court notes that fact.
Yes, yes.
That yes.
And my lord, my humble submit is the Aruta and a feat of race, both the parties ensued with quarrel relating to grappling over homestead land. And it has been, Lord, humble submission, my lord, the prosecution has tried to make a heel out of a mole. This is a Really, my lord, the entire case I have gone through. My lord, if you also permit me, I will also further ponder over the issue. But it is actually prosecutors trying to, I mean, with the lordship's permission, may I reiterate, it is a heel out of a mole.
Yes.
Injury itself speaks about the gravamen of the incident. Apart from bereft of other contradiction and other thing.
He was admitted to hospital.
Yes, yes, he was admitted on self-same discharge.
Medical, huh?
Yes. I mean, I'll place a short note of submission or judgment and close your lords.
The crowbar and
Not seized. That is another weapon of offense not seized.
the only problem is the head injury.
And the nature of the injury, as you
Maybe he was lucky.
Yes. That I don't. I
He was lucky. Because why have you aimed at the head? That was the intention.
My lord, then my lord, if the prosecution does not establish there is any intervening circumstance which
You see, again you have said the double-edged weapon. Civil dispute was there. That was the object of
admitted.
attacking.
That is one.
That is the object of attack.
That I cannot reveal out.
Is there. Evidence is there that there is a head injury.
Yes.
Might be the head injury is not much serious, but the fact that there was a head injury, for 307, injury is not more important. The intention is also important.
But my humble submission.
Aiming at the head and attacking someone.
My humble submission.
And he was lucky then.
My humble submission, with lordship's query, my lord, that even there is a civil litigation, and my lord, my humble submission is like this, my lord. It has to be taken into circumference the attending circumstance that all the persons were assembled there when the incident was taken place. If there is had the appellants, two appellants, my lord, had they had any intention, they could have succeeded in their attempt. Therefore, my humble submission, my lord, assuming for the sake.
Intention can be elucidated from two facts in this case.
Yes.
First is there was a motive because there is a civil
litigation
going on, suits were pending. This is one of the reasons intention is there. Second is aiming at the head by a weapon of this nature. These are the two things which creates a circumstances against you for 307.
My humble submission,
323.
my humble submission, my lord, with humble submission to your lordship, that so far the second query of your lordship is concerned, that he heard the two appellants. There are two appellants and the victim is one. And they were assuming for the sake of our prosecution said Qatari and Cobra. So had they had any intention, my lordship, my lord, whether they had any intention or not. Had they had any intention, I don't deny, Lord. Keep it in the back.
You only brought on record intention part by saying that we had a civil dispute. You on the record you have brought it.
Yes.
You means your client have brought it on record the intention part.
Intention part.
That suit was pending and all.
But that intention may give rise to any ensuing quarrel between the two families. But it has not been established to the extent that they intended to commit murder, which has been circumvented by any supervening circumstances. Your lordship is, has a temple of knowledge in this matter, my lord. Your lordship may decipher as to whether the appellant had any intention to commit murder. That is only, my lord. Then, my lord, only it may be scaled down to any 324 at best, my lord. Even 320 is also may not come within the grievous shot. There is no grievous shot, except, my lord, therefore, since the, my lord, my humble submission, since the case does not fit into 320, the prosecution has deliberately tried to establish a case under section 307 by saying that they had intention to kill. But the Dr. P.W. 8 has crystal clear that the nature of injury is very simple.
Yes, what do you say? Can you convert it to 323 or?
Yes.
As it appears, my lord, from the My lord,
Here's a very difficult case.
PW6, my lord. Though my lord, file not with me, my lord. PW6, my lord. With a intent, he has assault with a crowbar to the head, my lord. Assault to head, my lord. That is the intention, my lord, to kill, my lord. So he can assault me not any part, any vital, without any vital part. Then matter would have been different, my lord. Any injury to assault, he is a very lucky. Then he has sustained, my lord. So there, admittedly, there is a intention.
Undergone, period undergone. Period undergone. How much?
Period undergone. There are two appellant. One has been apprehended and remained in custody for the record, but other one is surrendered because Honorable High Court has granted anticipatory bail to surrender and go on bail. The other one, Gangadhar, released by virtue of the order. This period incarceration probably
very less.
I may permitted to verify the LCR.
You just verify.
LCR.
And
LCR.
sentence is 5 years.
Yes.
We'll try to modify.
Yes, yeah.
326. Max 326. 326 no, either 323 or 307.
Yes.
There is no question of 323 because
so as to
it is a simple injury.
Well,
if intention part is taken out, then it come down to
yes,
323.
deep love lies, my lord. Deep love lies. It intention part.
If intention is there, it will be 307.
My lord.
I have no say.
So either 307 or 320.
My lord, my lord.
Not in between anything. Just check it up.
Well, deep love lies, my lord.
How to get out of the intention part? Just.
I'll.
No. We'll hear it. We'll put it next week. Yes.
Next.
65.
Item 65 may be pardoned, my lord. Mr. Das Land senior counsel is supposed to argue this matter, my lord. Last Monday he was appearing. He is held up in another court, my lord. I am taking a password for the day. Tomorrow may be taken up, my lord. This matter.
What is this matter about?
It is conviction under section 147, 149, my lord, 506 for 2 years imprisonment.
We'll put it in the weekly.
Weekly.
Next week, my lord.
Yes. Next.
Bless you.
Items IMBX. So item 66, I am appearing VC, my lord. I mean permitted to submit. Today I have personal difficulty. Let it be next Monday, let's see. I could not go.
He has a personal difficulty. Let it be. Huh?
Millard.
Yes. 67.
Grateful.
I pray for a short action.
Why, sir?
Because part of my file, my lord, in my office, it has been dispersed and I could file, my lord, it is there.
It
But
is
the lower court part.
it's
my
the
lord,
matter, 2014 matter.
My lord, conviction recorded on section 307. And it has been confirmed by the appellate court.
You have, you don't have paperwork and all?
My lord?
Paperwork you don't have.
My lord, I don't have part of some of the relevant.
Learned counsel for the petitioner submits that he
On
has
5th August, my lord.
misplaced his file and want to reconstruct the same. 1 week time granted to do so. Release the matter.
5th August, my lord.
Don't decide the date, they will give.
Lord.
Yes.
We commencing.
Yes.
Pardon your lordship. Beg pardon your lordship. Item 58, my lords. The password that is permitted to withdraw with liberty, my lord, for filing a better application.
58.
Yes, my lords.
This is that vigilance matter, my lord.
Huh? No. This one?
This is that case, my lord. We had I appraise your lordship about the Ranchi University certificate matters.
Learned counsel for the petitioner.
My lord, that is a transfer bill.
Seeks to withdraw the present revision petition.
With liberty, my lord. So filing.
Liberty is always there.
It's conviction.
And this is withdrawn. Yes. Supplementary anything, any method, any.
3 passwords are there. And we'll take that.
3 passwords. We will chair construct video. 1. Item 1. 5 minutes.
May I please your lordship?
Yes.
On behalf of my learned senior, pray for adjournment.
No adjournment.
My lord,
95 matter, no adjournment. 1995 matter you are asking for adjournment. Just
Sir,
imagine.
due to house shifting file was.
Whatever you tell me. Yes,
Grant is
Mr.
for-
Yes, Mr. Rijvi, assist.
My lords, no, he is alive. We have taken the instruction. He's convicted under section 5(1) and 5(2) and 409. Misappropriation of 7,425 rupees.
You didn't appear last date of hearing. Today you are coming and asking time. 1995 matter. How many years you'll keep on asking for time like this? See, the earlier also you didn't appear. This appeal is pending since 1995. Have you read the order? 26/6/2024. This appeal is pending since 1995. The status of the appellant is not known. This was now you
Yes, he's
came to
alive.
know this. What is this matter?
Grant the last chance.
No. You didn't appear consistently. You are not appearing all of a sudden appearing at all. Yes. He will address and you note it down and tell your senior that he will also address. I will not adjourn a single matter which is of 90s. 92, 93, 95. These matters, you please. I'll just pass it over on your request. Beyond that, nothing. I'm just passing it over. I'll just pass over, Mr. Rajvi. Get ready. And give. Yes.
May you keep it tomorrow, madam?
Which one?
That item 1.
Item 1. I'm just passing it over.
Because it's transfer matter.
I'm passing it over. If he will argue.
You keep it tomorrow. I will file a written note of argument also.
Come with written note of argument. No problem. I'll keep it reserved and I'll hear him. In so far as your part is concerned, I'll hear you tomorrow. Don't worry. I'll hear him.
Yes.
For the timing, see 95 matters.
Yes, I
please
do agree.
try to understand.
I do agree.
And these matters are lying since last many decades.
Yes. That is it.
Yes.
Item 2.
Lordship instruction was sought for regarding the whereabouts of the present
Yes,
appellant.
alive
Lordship
matters.
is very much alive, Lordship. I received instruction. Today he is going to turn up in my chamber, Lordship. So matter may be adjourned any day this week, Lordship. May be taken off Friday or next.
He is alive.
Yes, sir.
Yes.
Alive. Huh?
Alive.
Alive. So let it be there in the list. Get ready to come tomorrow. It will be there on the list. I am not going to give adjournment. It will
Today
remain.
he will be coming for.
It will be remaining in
Yes,
the
sir,
list. You get prepare and come. 97 matter.
Yes.
Yes.
Obviously.
Item 3.
In Mr. Rijvi, in 90s,
Yes.
91 to
90s to up to 2000.
2000, whatever matters are there, you get ready so that all the matters we will finish up next week.
Right.
Whether they are the other
They
side
are
there or not,
Yes.
no botheration. We will finish up 90s, all the matters of 1990s.
Yes.
The item 3 minute.
Yes.
Amicus to minute. Last week I have submitted the paper book minute. He was convicted under section 7 of the PC Act minute. And acquitted under section 13(1)(d) and 13(2) of the minute PC Act minute. The sentence to
Have you prepared written note?
I have not prepared. Last week when I have received the copy of the paper book minute. Last Friday. The input judgment was at page 19. He was sentenced to honorable arrive for 6 months and to pay fine of rupees 2,000. In default, arrive for more than month more minute. During trial minute, the prosecution examined as many as 8 witnesses minute. PW4 is the defense.
Approved. Yes, you have the paper, no?
Yes.
You have paper.
Yes, but I'm not prepared. So let him submit. I will submit tomorrow. Let him complete.
Let it be tomorrow?
Yes,
let it be tomorrow. And get this thing. Let it remain in the board. Huh?
Yes,
7. Conviction under section 7.
Yes. And he was alive or not? He was taking instruction. But,
no, he is not ready.
Whether he is alive, this petition is alive.
He is alive. That's what he is alive. That's another issue.
Yes, madam.
Because he is appearing as an amicus on
Yes,
my
madam. Yes.
Let's check it up. What was his age when?
Now will be 64, 67 minute.
No,
67.
he was
2003 minute is 45 years minute.
67 minutes.
67. 60 years.
he was 45 in 2003.
3 yes.
Yes.
Now was 66 or 67. He must be alive.
Must be alive.
Charge sheet, let us see. Charge sheet. Is Gangadhar Pradhan?
Pradhan.
Gangadhar
Yes.
Pradhan.
He must be alive.
Yes.
Let it be tomorrow. Huh?
Yes.
Get ready.
Yes.
Item 4.
My item 4, my lord, is appellant number 2 has passed on my
Appellant 2.
death certificate.
How many appellants are there?
One appellant is there.
Hmm? There are 2 appellants.
TRL 100 of 2020.
No, 100 no, 112.
112.
112 at 3.
Learned counsel for the appellant hands up the death certificate of appellant number 2.
Kashmiri Lal Jinda.
Kashmiri Lal Jindal is taken on record. The certificate indicates that the appellant has expired on 30/2013. Hence, in this appeal stands awaited qua the appellant number 2. What about appellant number 1?
He was also 90 years old, my lord. He's bedridden. Bedridden.
Alive. Alive. But bedridden. This is what he says.
What are the offenses?
13-1, my lord.
13-1.
But paperwork has not supplied. Paperwork will supply.
And take it from the registry.
Take let counsel the counsel for the appellant further submits that formality submits that the appellant number 1 is now 90 years old. 90 years old. He want to reconstruct the file to address the court accordingly. Reach him at
Paperwork.
So, DC directed to supply paperwork. Yes.
Item 5.
I am ready. May I begin?
Yes, Mr. Rijvi, ready?
No, no,
Huh?
He never gets ready. ଆଜି କରିବେ ନା ଆଉ ଗୋଟେ ଦିନ କରିବେ?
Fix a date.
ପରଦିନ କାଲି ତ ଗୋଟେ ରହିଲା ଏଇଟା ପରଦିନ ଥାଉ. Day after tomorrow.
Let it be there in the board itself. We'll see. Let it be there in the board. Since you are prepared, whenever time permits, tomorrow or day after, I'll take it up. Let it be there on the board.
Lordship.
Next.
Item 6.
Item 6, my lord. Item 6 was mentioned. Item 6, my lord, I am on behalf of Mr. Bose.
Yes.
Due to want of some
two is,
instruction.
yes,
Two is now Thursday or Friday of this week.
Let it be there on the board. Let it be there. I'll take it Thursday. No problem.
the matters which has been indicated that it will take a minutes. That case can be disposed of today. So,
I don't know why.
And my learned friend's case is concerned. I don't stand on the way.
1 second.
Let it be the list.
I'll hear both the matters.
No, let it in the list. I need some more time. Lord. I
Sir,
cannot
over
complete.
one letter to be produced.
Yes.
That letter is
No,
there.
no. That
Two
is
occasions,
no,
Mr. Rath.
Mr. Rath has taken the time to produce a letter. He has prepared all this thing. My whole problem is on that occasion. I could not say each individual case. What are the materials disclosing grave suspicion or that include that only applies to a lot with 15-20 minutes. I'll finish it. Let it be in the list.
Tomorrow.
I pray
Tomorrow.
Third step. Because after launch cases are 3 to, in fact, you both are very hard.
Because the problem is I have already heard extensively. I forget it. Then again,
No, I don't pray for the next week. No. This week only, only I pray, Thursday will be.
Lord, I am
convenient.
surprised why this kind of adjournments are being sought for.
No, the
Adjournments are
reason
all over.
now we are taking
One letter was supposed to be produced and it is here.
No, it's not so simple. That is
देखो
this
तो
case.
एक ही argument का सिद्ध आधा घंटा ऊपर
Lord, this case has.
I have heard and I.
Yes, your lordship heard him extensively. But
Not me.
One minute. No. I have not come. These are 4 cases are there, my lord. This is one of the few cases which have traveled twice to Supreme Court and twice to this Honorable Court. So the possibility of going another round may not be ruled out, my lord. That's why I should not leave any stone unturned, my lord. That's why pray, my lord, I will only take 15 to 20 minutes, but in
Okay, tomorrow at 2 o'clock.
Tomorrow, my lord, another matter, sir. Your lordship picks all old matters, my lord. We both are
What to
preparing.
do? See,
Wednesday or
we
Thursday?
adjust the board like this. If you ask for adjournment, then the board is, collapse. I am free. I go to my chamber. What to do?
Let it come Thursday or Tuesday.
Thursday, there will be a matter. The board is adjusted in such a fashion.
No, all cases are posted at 2. That's will give. Tomorrow's another matters are there. That's why, not
Tomorrow's matter.
This
This is also a case.
So I would have good dinner.
Instead of 2 p.m., let it come
10:30.
before lunch.
10:30.
Tomorrow, day after, any day.
Thursday, Thursday. I don't pray Friday. Friday after lunch, no court minutes. Thursday, it will be. This is my promise. It will go. It will finish.
Mr. Das is seeking the final opportunity to address the court in this matter. In the interest of justice, matter is adjourned to Thursday, and it is made clear that in the event, Mr. Das.
Since I assured the circle,
ready to argue the matter, he may submit a written submission.
No clarity order is required. It's my assurance to this court. I'll come back.
Otherwise, you get ready with the written submission and give it. I'll read it and yes. I'll not further will.
And so far that 2 p.m. matters, another matter, Mr. Naik is there.
One rest.
That will continue. No. 2 p.m. matters are listed. It will come in the morning.
It is a normal list.
Normal list.
Supplementary.
With the lordship's permission, Item 55, that is regarding to 130 NI. My client is so suffering. Out of 10 votes, he has sold 4 votes and he has collected 20 to 25,000 in today money. Our rest amount is to be arranged within 8 to 10 days to repay the entire amount. That is my senior also told that 65,000. After selling
55.
that 55, 130 NI.
Already order passed?
No, pass over.
Pass over.
Item 55.
So let it be there on the board. You arrange the money, pay, and I'll take it up.
It may not be taken up today, but
I am not taking it up. I am not touching it. As if I have not taken it.
Item 45 notes. But the indication is that it will take not 2 today notes. Out of the 3 cases, 2 revision cases, I suggest it can be disposed of. My learned senior, Mr. Naik is there because last time he was arguing the conviction is under section 177 IPC, RI for 1 month, my lords.
1 minute. 2 small matters are there before. 2 pass over. 1 pass over. Yes. Item 49.
My lord, permitted to withdraw. I have filed memo.
Withdraw. Memo.
Yes.
49.
50.
My lord is kind enough to issue notice to the person. It's a against the cancellation of bail.
Yes.
Appeal. My friend is appealing. Let him take it after 2 weeks or 3 weeks.
You are for petitioner.
I am for
You are
petitioner.
seeking cancellation.
Yes, yes. My friend has appeared today.
What is the offense?
326. Yes.
Initially it is
25 that
One of the petition, opposite party number 4 arrested and released on bail. Others are extended benefit under section 41A CRPC.
Why cancellation?
With all respect, because 41 my lord, that restrict to 7 years.
Charge sheet submitted under section 325.
No.
Yes, yes.
No, certainly not. The magistrate has taken cognizance under
Magistrate taken-
326.
Cognizance taken 326. But charge sheet submitted under section.
And thereafter only he has regularized. How will he regularize, my lord? All things will taken up, my lord, may take.
That should have been sessions court.
No. Tribal or magistrate.
Implemented life is.
So what is the problem?
The life
I didn't follow you actually.
Well, my humble submission is that the police, my lord, take my lord,
41 notice was given to them.
given, and the police has extended the benefit. Although the injuries are there, the fracture injuries are there, all these things there. Apparently, it was there, but the police, my lord, because of some influence, has released them on interim bail. Sorry, on 41, extending 41. Now, when the court has placed the charge sheet, in the charge sheet, magistrate has taken 326. Thereafter, only while the magistrate has regularized the same, which he cannot.
It's regularization or granting bail?
That regularization means he has granted bail.
He applied mind and.
No.
Let us see the order.
That's
It was an application or what?
Yes.
Let us see. Where is that order?
Maybe after 2 weeks, I have not prepared. I have also another matter. Only one next week.
Next week, because once the bail is granted, if you delay it, on that ground only it will be dismissed.
No, I am not. I have brought to the notice of this honorable court and my lord is kind enough to.
Friday.
Friday or evening. Coming Monday.
Monday. Yes, Monday. So file your Vokalatnama and if you want.
I have already.
And if you want some condition, we'll impose whatever.
Monday, my lord.
No, today I'll dispose it.
I have not.
Asking the trial court to
No, in such a case, my lord,
appropriate condition.
my lord, in such a case, my lord is right to this extent. The honorable court either interfere to this extent that because of the fact that bail has not been granted properly, cancel the bail and directly for all things. 437(5), my lord, or the 439 subclause 2 is the only provision. Or else, in some cases, as my lord proposing, because of the fact, my lord, where the bail has been granted, in some cases, my lord is also imposing stringent condition and directing for LADs for all these things. Both these things can be possible on Monday. My lord will take it Monday.
But I will not cancel the bail.
Yes, my lord, please, yes, my lord. If I will satisfy, my lord, definitely my lord will interfere. If I fail, then
some condition or something if you want, I will impose. But
37 subclause 5. Always available with my friend, my lord.
No, I don't dispute that.
On bail matters, why unnecessary so technicality?
No, he cannot. Anyway, I'll satisfy.
We'll see. Monday. Yes, sir. 45. There are 3 matters, huh?
I am appearing, my lord, in criminal division number 1416 of 2010.
1416.
Yes, my lord.
Yes,
2010.
First item,
On
yes.
behalf of accused Hemanta Kumar Sodangi.
Yes.
Petitioner is Hemanta Kumar Sodangi, my lord, who was a senior clerk at that time in the office of the Assistant Electrical Inspector Bhubaneswar, my lord. And the background of this fact of this case is, my lord, that the one certificate for one application was made before the electrical inspector, my lord, for issuing him a complaint certificate in respect of a building which is known as Gem Palace. After completion of the electric wiring, my lord, unless a certificate by the competent authority, the inspector is produced, my lord, the line will not be charged. This being the formality, my lord, he has requested this patra of the principal accused, my lord, to supply him the certificate. Probably he delayed. He suspected that he wants something or he wants bribe, for which he reported the matter in vigilance before the vigilance. A trap as usual, my lord. The affair was registered. A trap was conducted. A trap was prepared and ultimately is conducted. And during trap, my lord, it was found that K. Rajiv Lochan Patra, who is the principal accused, my lord, he has demanded, as per the prosecution case, my lord, he has demanded the amount of rupees 5,000 and he has accepted. So for the present petition is concerned, my lord, on the date of the incident, on the date when the raid was conducted, my lord, he was present along with other staffs also. The allegation is, my lord, not against him that he has made any demand. This petition, so for this petition is concerned, the allegation is not that he has made any demand. The allegation also is not that he has accepted any bribe directly from the informant. Only the allegation against him, my lord. During the transaction, while he passed on the envelope, the informant passed on the envelope to the principal accused. The principal accused passed on the envelope to the other accused, my lord, whose name is
Raju Digal.
Yes, Raj Digal. And it is stated that Digal passed on the envelope to these petitioners, who out of curiosity opened it, found that 5,000 rupees or some 10,000 rupees was there inside the envelope. Then he again returned that to Raju Digal. This is the only involvement so far the present petition is concerned. Admittedly, there was no demand. Admittedly, he has nothing to do.
Even Raju has not demanded.
No, Raju has
The
not.
demand is by
Therefore,
Rajiv, and it was given to Rajiv. Rajiv gave it to Raju. Raju gave it to you, and
Yes.
you saw and gave it back.
Yes. So this being the positions, my lord, I have not been also charged, or I have not been prosecuted, my lord, for the offence under Section 13(2) of the Prevention of Corruption Act. I was prosecuted, my lord. I was charged under Section 177 of the IPC and ultimately convicted under that section. For a moment, your lordship may kindly see Section 177. Lordship may kindly see Section 177 IPC.
Yes.
Whoever being legally bound to furnish informations on any subject to any public servant, as such, furnishes as true the informations on the subject which he knows or has reasons to believe to be false, shall be punished with simple imprisonment for a term which may extend to 6 months, or with a fine which may extend to 1,000 rupees, or if the informations which is legally bound to give respects the commission of the offence, or is required for the purpose of preventing the commission of an offence.
Oh, the allegation is why, knowing all these things, why he is not informed.
Not informing is that is my responsibility. Not informing my lord is not. Your lordship may kind say, I know that this is bribe, and I informed him saying that the money was given for some other purpose. I knew. Your lordship may once again see, whoever being legally bound to furnish informations under which provision of law, my lord, I am legally to bound furnish informations, and to whom I would have submitted, my lord, on any subject to any public servant, as such, furnishes as the informations on the subject which he knows or has reasons to believe to be false, shall be punished with a simple imprisonment. I must, the ingredients, my lord. So I must inform something which I knew that it is not correct. And I am legally bound to furnish such informations to the authority, under which provision of
The
law.
raiding party comes, where is the question of informing again?
Yes, raiding party come, immediately they.
If it is not known to the investigating agency,
yes,
then it is a
Exactly.
duty on you to go and tell that he is taking bribe.
Exactly, man. Exactly.
If the raid party comes, where is the question of informing to the raid party again?
Exactly.
Yes,
That is my only point. That is my only point.
What is this allegation?
The allegation is, my lord, if lordship turn
In
to.
the story, whatever, I have not seen the paper.
That is the story.
Whatever the story is says.
I extend full solidarity with regard to my
How can you bring 177?
My point is, my lord, super factual aspect, he has put forth all the matters very correctly, accurately, my lords. But let me find out what is the complexity and what is the finding to that extent, my lords.
Let us see the finding.
Lordship, turn to the page 22, my lords.
Already raiding party is there.
Whom
he will tell?
No, my lord.
Is it bribe money? You cite him as a witness?
With regard to the scenarios, with regard to trafficking cases and all this, my lord, this is for the first time I also come across, my lord. But diverging certain matters, my lord, which we are within their knowledge, my lord. Let's turn to page 20.
Answer to me, which public servant you were expecting that he should have disclosed this information? Because public servant knew the information already.
Yes. My lord, senior's turn is that, my lord. Let's turn to page 22, my lords.
20?
Page 22, my lord, of the brief of.
Yes.
It's turn to brief, my lord. It's the issue was whether the accused person being legally bound to furnish information, have furnished information as to which they knew or reason to believe to be false. That was the issue, and that has been answered.
1 minute, let me get it. Yes. 20?
22 minutes.
Yes. 22, yes.
First line, thus the accused Patra.
That's both the accused. Patra.
Thus both the accused Patra and Sarangi were well aware of the fact that the bribe amount was received towards issue of satisfactory report, and the accused Sarangi has taken the envelope from the accused Patra and has verified the same and had concealed the same with the accused Raju Digal, though he was legally bound to state that fact before the vigilance police as is related to a cognizable offense, and every citizen of India is legally bound to inform the police about the cognizable offense.
The police knows it. What is there is question of informing?
This is the
Police
finding.
themselves knows it.
This is the findings, Milords, and the with regard to Milords, conviction, Milords, and the sentence, Milord, is 1 month.
He could have been a very good witness for you.
Another one, the Raju. Raju, in fact, Raju, Lords, you can turn to the same brief, Lords. Same brief, Lords, you turn to page 4, Lord. Lords, holding the brief, Lord, page 4, Lords. I agree. Illustrate on page 4, paragraph 9, Lords. That evidence was quoted, my learned friends, Lords.
Yes.
When para 9, Lord, I'm quoting the quoting portion. When Raju Digal was for
1 minute,
page 4, Lords.
Page 4 after the judgment.
No, Lord, it's a petition. The revision petition.
Petition. Yes.
Page 4, para 9. That quoting portion. When Raju Digal was further examined, he disclosed that accused B. Rajiv Lochan Patra had handed over the envelope to him. At that time, senior clerk Hemant Kumar Sarangi, the petition in this case, took the envelope from Raju Digal and finding money inside the envelope, he again returned the said envelope to Raju Digal.
How does he know it's a bribe money or what?
And you also turn to next page, the another part of that evidence. Next page. He has fairly stated that thing.
Yes.
Thereafter, I hope you also got it.
Thereafter,
Deagle stated that Sipatra handed over the envelope containing the money to him and asked to keep for some time. When he received the envelope containing the money, Sri H.K. Sarangi, the petitioner, senior clerk, took the same and counted it and found that the money was inside it. Then Deagle kept it inside the late pant pocket with him. So he was aware.
Aware what? This is bribe money.
About the envelope.
He knew that there is an envelope and there was money. But how will you get that he knew that it is bribe money? And which public servants you were expecting to tell? Yes. The raid party was already there.
So for the process.
Just a minute. And the subsequent conduct is minor. While he found that money is inside, he immediately returned to the girl. He has not kept it.
And
that is immediate conduct.
So maybe he knew that it is a bribe money, so therefore to get out of the raiding party.
But the prosecution case is, my lords,
he was a good man.
Knowing the commission of the offense, willfully withholds or misinforms.
Have you asked him? Show me any evidence for the IO that he was asked and he did not disclose. Show me.
So that is available in the appeal only.
Then only you can make 173. Have you asked him?
Well, in fact, the appeal is the main accused, my lord. My learned friend.
No, you in this case you
in this case only the evidence.
That the raiding party asked him, "What is this money is about?" Then he say that I will not tell.
Yes.
Then you bring 177.
Well, in this case, my lord, appeal is there. Appeal, the paper book is there that contains the evidence.
Paper book.
No.
There is nothing in this. No, same evidence same. You show me any place who say that despite I am asking.
Didn't disclose. Or misinformed.
And that is the requirement of 177. That is the requirement of 177.
Next law.
The two revisions on the stance. two revisions.
I'll record everything, but I couldn't. There is nothing, no case is made out. What? And what is the reason trial court is giving?
The reasons that they
He remained
deliberately.
silent. He remained silent.
And writing Indian constitution and all. He's writing about Indian constitution, right
Yes,
of
yeah,
getting-
toil hard.
except reading the evidence.
Yes, toil hard.
To only to justify without evidence, if you justify, you write fantastic language and try to justify it. But you have to you have to see what are the evidence.
They didn't-
177 is very clear, but knowing that there is bribe money, if he doesn't do it,
And this is,
raiding party goes, who and you have not asked him.
Now, in this case, my lord, if you also see the cost title, my lord, after so many years, my lord, this is the first case I say, apart from the main accused in a trap case, my lord, other two persons also face.
Rajiv Lochan may have a difficulty, but insofar as Diggal, what about Diggal?
My friend who is in the appeal, my lord, you take care of him. And there is a lot of materials, my lord, about the
Rajiv, what about the Raju Diggal, same 177?
And that to police, they're expecting that it should be diverse before the police.
Just imagine a situation.
I
A
agree.
party goes and some main accused is asking money and taking money. Somehow it comes to the hands of other staff. Everybody is scared because raiding party is there. Do you expect that they'll disclose? मैं आगे सिन्नू उतला पैसा अपन वापस करूँ तू. It's so unnatural. What about Diggal?
Diggal is also here before your.
177. Huh?
177.
10 of 2000.
ताका appear के कुछ.
Diggal also.
Yeah, page 39, 177.
Same charge, 177.
Same, so when arrive for one.
Diggal also goes. Rajiv, you talk about Diggal and both of.
Rajiv, did it come usual course?
Appeal aswa, uthara aswa, appeal aswa.
Filter, you weekly as well.
Who is appearing for Rajiv? We will dispose of all the three. Show me, do you have anything to say? Otherwise, it's a case of conviction for you.
Yes.
Otherwise, let's not dispose the
Because
two revision first.
acceptance, demand and everything is there in you or against you. These two people were side actors. And raiding party, so rope in everybody. But how will you get out of the evidence? In your case, I think.
There are a lot of evidence. Clinching piece of evidence on the case. Clinching piece of evidence.
Comparison of note and. Come to page 88 of the evidence of the default.
At page 88, my lord.
Senior na time magu
Time nahi.
Si time magu jana senior na.
Tomorrow, let's see.
No, okay, but let us see the overall other thing. Is there any chance of acquittal here? No.
Page 88 paper book notes. The decoy.
88. Just beginning with the last fourth line. When I met Mr. Patra, he verified the file and raised some objection. I complied the same. Mr. Patra came to the building for inspection on 3/9/2000.
I may permitted to take a lot.
Yes.
Mr. Patra was satisfied after verifying the motion. When I requested him to give report on that day, he demanded money. On the next day, Mr.
Patra demanded bribe of
Who is
rupees
this
10.
Patra?
My lords, he happens to be the.
Then according to you, demand and acceptance both are.
Yes, my lords.
And read
Yes, my lords.
Yes,
He happens to be the electrical inspector, my lords.
For you, it may be a difficult case.
Yes, because he is the person who will be giving the completion certificate, and he is in the hem of all the affairs. Incidentally, these two persons were there at that time. Raju Diggal happens to be one of the electrical contractors also. He is not an official. Hemant Sarangi was the clerk.
They were there, but 177.
No, that is not.
चलो ये दो मैटर अभी दे देना और ये this matter
Weekly matters, let it be there in the weekly.
let it be there in the weekly.
Yes.
These two matters that is 10 of revision 10 of 11 and 14167. ये दो अभी करा दे ठीक है immediately
appeal ma'am
separate तो है ही ना
separate अच्छी data revision और खत्म yes
weekly
Any-
Had my learner senior been there, it would have been disposed of.
Ah.
This unfortunately is not there. In fact, I was afraid if I take some time, he will get angry on me. The morning he got angry. Now he's not there. Yes.
Because he was sure about acquittal there, so therefore he got angry.
Maybe.
Uh,
Lordships are correct.
Maybe, but here case is difficult case,
Yeah.
so therefore obviously. Chalo, send it. Okay, thank you.